Wait, wait, wait. Ready? Good evening and welcome once again to another program of Issues in the News, where we discuss the events taking place in Guyana over the past week or so. And as is the norm, we are never without issues to discuss in Guyana. I just remarked that there is not a moment in my life that is not action packed with issues of importance. So I want to begin by welcoming our viewers who are joining us on television from Region 5, Mahaica to West Coast Berbice, welcome. To our viewers who are joining us on television in Region 6, east bank of the Berbice River, all the way to Molson Creek and even beyond, welcome to another program of Issues in the News. And to the thousands of you who are joining us on Facebook Live, right across the length and breadth of Guyana, North America, the Caribbean, Europe, further afield, and of course, those of us who are joining us on our newly launched platform, YouTube, welcome once again to another program of Issues in the News. Please share this program. Press that share button on your phone. Press that share button on your computer so that as many persons as possible can join us in tonight's discussion. Again, please remember to share this program. Press that share button on your phone, on your computer, so that your friends and followers can be part of our audience and be part of our discussions. I see Keith George is watching, Francis Kunji is watching, Savitri Warnott is watching, Mike Bikam, Horace Sankar, Vishnu Prasad, Basil Siraj, Deolal Suku, and Wilbert Stevenson from Brooklyn, and so many people, Krishna and Paul. So many of you have joined us already. Thank you very much. And please press that share button on your phone or on your computer or on your iPad to ensure that as many persons as possible join us in tonight's discussion. I want to begin by dealing with an issue relating to a decision of one of our learned magistrates. Now, many a times you have been asking me on this program, you have been criticizing me and criticizing the government in respect of charges that are being filed that are not being heard by the magistrates. You have been criticizing me and criticizing the government regarding decisions that our magistrates make. Sometimes you criticize me for decisions that the judges make. Permit me to remind you that our democracy and our constitutional system is based upon the doctrine of separation of powers, whereby the judiciary is responsible for the hearing and determination of all judicial matters, which includes criminal charges. It is the judiciary that determines how charges are heard, how they are determined. It is the judiciary that makes decisions in relation to how these cases are conducted. And it is the judiciary that determines the outcome of these cases. The rule of law and the doctrine of separation of powers insulates, and properly so, the judiciary from any form of influence whatsoever, and mandate that it must be independent in the execution and discharge of its functions. And that independence we must all protect and preserve because it's a central pillar of our constitutional structure and a fundamental tenet of our democracy. We are required as citizens not to attribute ulterior or immoral motives to the judiciary and its officers. We are prohibited from launching scathing and scurrilous attacks against the judiciary and its officers. And I speak here, when I say judiciary and its officers, I include the magistrates. However, the law permits constructive and fair criticisms, even outspoken criticisms, against the judiciary and its officers if the situation merits such commentary. And unfortunately, I, as Attorney General, Minister of Legal Affairs, and Minister with responsibility for the justice sector, I have had the unfortunate task, especially in recent times, to offer critical commentary on the manner in which certain types of criminal charges are being dealt with, handled, and adjudicated upon by our magistrates in particular. Today, I had the occasion, regrettably once again, to offer critical remarks in respect of a ruling handed down by one of our magistrates. The case involved a charge of misconduct in public office instituted against former Minister of Finance Winston Jordan. The transaction to which give rise to the charge was the sale and transferal of title of a wharf, government's asset, to the value of 40 million US by Mr. Jordan to a private company for a mere 100,000 US. And the transaction was concluded and title vested sometime in June or July 2020, after Mr. Jordan's government would have lost governmental office at the March 2nd, 2020 elections. While Mr. Jordan's government illegally retained the reins of government, Mr. Jordan, as Minister of Finance, saw it fit to conclude the vesting of title, free from all encumbrance, for a 40 million US state property when the purchaser only paid 100,000 US dollars, 20 million Guyana dollars, for a 40 million US dollar property. 8 billion Guyana dollars. And Mr. Jordan issued a title that is free from any liability or encumbrance. So the private company, walked away with a clean title. Mr. Jordan was charged with misconduct in public office. And today, a magistrate ruled, accepting a no-case submission, ruled that Mr. Jordan is not a public officer and therefore could not have committed that offense. Misconduct in public office requires the person who is the subject of the charge to be a public officer in law. And the magistrate ruled that Mr. Jordan, as Minister of Finance, did not fall within the definition of who is a public officer for the purpose of discharge. Now, viewers would recall, while we were in the opposition, Dr. Ashley Singh, who was a Minister of Finance between 2011 to 2015, and Winston Brassington, the two sold a property that now houses Movie Tongue at Liliendal after a public bidding process to the persons who own the Movie Tongue establishment. The decision to sell was one that was approved by the Cabinet of Guyana. In Mr. Jordan's case, there was no cabinet approval. Here, you had a legitimate government. In Mr. Jordan's case, the government had lost power. And Dr. Singh and Brassington were charged with misconduct in public office, the identical charge. Dr. Singh was the Minister of Finance. He held the identical position that Mr. Jordan held. I appeared. I filed proceedings in the High Court to challenge the legality of the charge on the very ground that Dr. Ashley Singh, as Minister of Finance, was not a public officer. The matter was heard by the Honorable Chief Justice Roxanne George. Detailed submissions were made by the Director of Public Prosecutions and yours truly and the other lawyers involved. And the learned Chief Justice delivered a written ruling on November the 18th, 2020. A written ruling in which the learned Chief Justice found, as a matter of law, that Dr. Ashley Singh, as Minister of Finance, was a public officer for the purpose of the charge. That decision of the learned Chief Justice was given to the learned magistrate, and written submissions were made. In law, there is a doctrine called stare decisis. By that doctrine, a High Court judge decision is binding on that of the magistrate. So, applying that principle, Chief Justice George's decision bound that particular magistrate. What that means is that magistrate had no jurisdictional freedom to depart or to disregard a ruling on the identical issue emanating under the hand of the Chief Justice of the country. Notwithstanding, the learned magistrate today ignored and or disregarded the decision of the Chief Justice by which she was precedentially bound and discharged Mr. Jordan from that charge. I hope that you are following what I am saying carefully and that I am breaking it down in a simple and straightforward way so that you are following the legal arguments. So today, in disregard of the Chief Justice's ruling and decision by which ought to have been binding on the learned magistrate ignored that and discharged Mr. Jordan. How do you rationalize such a decision? Is it that different persons are judged in the judiciary or in the magistracy by different principles of law? These are identical cases. How can a government, how can the state, how can the public, how can a sitting attorney general with responsibility for justice not be critical of such a ruling? A ruling that from all indications is one that is palpably, patently, and outrageously wrong. I hope those who are looking at this program will not fault me or members of the public for offering critical commentary on this decision. Law is based upon consistency, based upon precedent. I, as Attorney General, cannot prosecute cases. I am not responsible and cannot be responsible for the way cases are determined by the judiciary. That's a domain that's independent, in which the judiciary has freedom to roam. But they are bound by principles of law and principles that govern judicial determination of cases. And one of those principles is the doctrine of precedent, and the principle is called the principle of stare decisis, by which a superior court's decision is binding on an inferior court, and that inferior court is thereby bound to follow the ruling of that superior court. And here it is, this learned magistrate simply decided that she is no longer bound by a decision of the Chief Justice of the country. This is a cause for concern. It must be a cause for concern, even within the judiciary, because it is incumbent on the judiciary, and it is the duty of the judiciary to conduct itself in such a manner that it continues to enjoy the public's confidence. I can't do it for the judiciary. The government can't do it for the judiciary. The judiciary must conduct itself in such a manner that it attracts and demands the public respect and the public's confidence. How do you get the public, how do you secure the public confidence when you have rulings of this type? And if this was an isolated ruling, then, one could have found it a little malleable. But it is not an isolated ruling. Many of the cases arising out of the elections, and many cases in which political personalities are charged, are treated in a particular way. And cases involving the ordinary Guyanese are treated differently. Magistrates are going to extreme lengths in recusing themselves from hearing these cases on the flimsiest of reasons and basis. These cases are unduly adjourned and protracted. And here it is, if I was in doubt, or if the public was in doubt about the approach of these magistrates in these cases, you have this ruling which dissipates the doubts. And in my humble view, sends a clear message, which is not a healthy message for the administration of justice. It is not a healthy message for the administration of justice. The state will decide what remedial actions will be taken. That's a matter for the Director of Public Prosecutions and those who instituted the charge. That's a different arm of the state. That doesn't fall within the purview of the government. But this matter involves a substantial piece of real estate of the state. And in any event, the government is entitled to express a view critical of the judiciary when the occasion warrants it. And this occasion certainly warrants it. And I've issued a public statement on this matter. It is not intended to bring the administration of justice into disrepute. It is simply intended to draw to the public's attention the egregious error and elementary error made by this learned magistrate. And it is not that the ruling of the Honorable Chief Justice was not handed to her. It shows the cavalier manner in which important cases are being treated. These are not matters that are important to the government of the day alone. These are matters that are important to the state. It is public property. Valued some 40 million US or $8 billion Guyana dollars, that was transferred by this minister after his government lost power to a private company, and the state only received 100,000 US or 20 million Guyana dollars. This is our property, your property, my property. And this minister signed a vesting order stating that the title which the private company is to receive is one that is free from any liabilities, debts, or outstanding monies. In other words, a clean title. The agreement of sale that he entered into was for a mere 1 million US, out of which 100,000 Guyana dollars was received. 100,000 US. 1 million US the property was sold for. 200 million Guyana dollars. That property is valued 8 billion or 40 million US. Sold by this minister. For 100,000 US. And clean title was passed. somebody is asking me what the government is going to do about this. The state has remedial actions that the state will consider taking. In a democracy, as I said, the government can't interfere with the judiciary. That is the constitutional democracy that we work so hard to create. So the appropriate channels will have to be exploited to seek remedial actions here. And that will be done in due course. So I thought that I'll start the program with offering my views on this ruling by the learned magistrate. In the public domain during the course of last week was a letter written by Mr. David Patterson, Member of Parliament, criticizing the Public Procurement Commission in respect of, according to Mr. Patterson, the chairperson's unwillingness to meet with him and the Commission's failure to address complaints that he has raised with the Commission. And I have no difficulty with anyone criticizing public authorities, constitutional commissions, and public officers. The public is entitled to criticize them. I have just criticized the judiciary for the past 25 minutes. So I encourage public criticisms against public agencies. But one must ensure that one does not go overboard, and I don't think that I have gone overboard, in attributing motives to public officials and to constitutional agencies, or threatening these agencies and their officers, or subjecting them to unwarranted public attacks. Mr. Patterson carried on in a tirade against this organ, the Public Procurement Commission. And they replied. And they said that they are not prepared to meet with Mr. Patterson personally, that they are interrogating the complaints which he has made, and that they are seeking legal guidance. And those reasons were communicated to Mr. Patterson. Yet, he proceeded to lambaste this Public Procurement Commission in the press. As I said, these public agencies, they have a duty to respond, but they also have the freedom to inform themselves of the issues and the law before they respond. And Mr. Patterson was written to and informed that the Public Procurement Commission was treating with his matter. But that did not satisfy Mr. Patterson. And, Mr. Patterson started to accuse the people of lack of transparency and of attributing to them illicit motives. And Mr. Patterson has a particular track record in government. This is the gentleman whose ministry, under his direction, purchased motion scales to the tune of some $70 million. I hope it's 70 million or 70,000 US. I can't recall. And paying for these scales, and did not go to the procurement process. The contract says that he is to pay a deposit, and when he receives the scale, then pay the balance. This fellow and his ministry pays the entire sum upon the signing of the contract. A contract which he did not go to the tender board for. He handpicked this person, this company, who turned out to be the company that was advising them on their elections campaign. A company that was never in the business of selling scales, but a company that was advising them electorally as a political party. And up to now, the scales have not been received by the government of Guyana. This is a gentleman who took monies from the Harbour Bridge and purchased for himself and his colleague minister bracelets and bangles as birthday gifts. This is a minister who, without the board's approval, the Harbour Bridge Corporation's board approval, took over $160 million and paid for a feasibility study to be done for a new Demerara Harbour Bridge. Did not get cabinet approval, did not go to the tender board. After sought to get ex post facto approval of the cabinet. And this gentleman is accusing the Public Procurement Commission of lack of accountability. And I am not defending the PPC. The PPC is an independent body. They can defend themselves. And they have issued a statement. But it is the constant attack on independent constitutional bodies that is worrying. And not for any, what up to now nobody understands what the wrong is. GCOM is the same thing. The chair of GCOM has received death threats from a member of the APNU AFC. So when these people don't get their ways, they resort to intimidation and threats and public attacks. I am looking at the comments here, and anyhow, if you want me to reply to any particular issue, please raise it here on the live, and I can try to address it as we proceed with the rest of the program. Now, we have passed the amendment to the Road Traffic Act relating to electric cycles. And I have seen again in the press some criticisms, and I've read the criticisms, and the criticisms are misplaced. Persons are still of the view that the law that was passed in the National Assembly recently in relation to e-cycles are intended to prohibit the use of these cycles. That is not the effect and impact of the law. The effect and impact of the law is to regulate these cycles. And what it does, it simply extends to e-cycle the regime of regulation which applies to motorcycles. That is all that it does. It applies the regulatory framework that applies to motorcycles. It does so to e-cycles as well. So you have to get registration, you have to get insurance, you have to wear helmets, and you have to comply with the other laws in relation to motorcycles. That is all that it does. And in the debate, both myself and Minister Ben were very careful in recognizing the utility of these bikes, their environmental friendly nature, that they are cheap and reliable, that they are expedient and they allow for speedy movement and transportation, and that they are cheap. So the government is not against the use of these cycles, but it's important that they be regulated like every other road users. And I hope that persons understand that the government is not against these cycles and are not punishing people for using the cycles. We encourage you to use whatever form of transportation you can afford. But naturally, we have to ensure that it follows, that the law applies to it. And it is brought into some form of regulation, like every other user of our public roadways. Local government elections, as you are aware, the local government election preparations are on their way, and elections are scheduled to take place on June 12th, 2023. And of course, APNU AFC continues their strategy of trying to stop the elections from taking place. So they have filed another set of legal proceedings in which they are seeking to challenge a decision made by GCOM since January of this year And that is the boundaries, the demarcation of boundaries, and the creation of new constituencies. They were saying that Minister Dharam Lal did not have that power, that GCOM has the power. Well, GCOM made the divisions and created the new constituencies since January. They didn't have a problem in January, February, March, April, May. In the month of May, and elections are June, just before, the month before the elections, they rushed to the court seeking to stop the elections from taking place. So 5 months, they did nothing. And in the month preceding the elections, they are rushing to court now to ask a court to stop the elections from taking place because of that decision that was made 5 months ago. I hope that you are seeing exactly what I've been saying over a year and a half ago, that constantly and relentlessly the APNU AFC have been engaging in strategies and tactics intended to delay these elections or prevent them from taking place. And again, I'm citing to you another example. The case is fixed, I believe, for the 30th of May before the High Court. So we will see what happens in that matter. But of course, GCOM has to appear, and whoever wishes to join the proceedings will be joining the proceedings and trying to put forward their own particular interest or the public's interest, as the case may be. Yesterday, as you would have seen from photographs published in the newspapers and on Facebook, a team including myself, the Registrar of Deeds, and personnel from the Director of Public Prosecutions, as well as members of the IDB team administering the Support for Criminal Justice project, as well as regional officials of Region Number 2, visited construction sites in that region, including a site that is being constructed, or a building that is being constructed to house the Deeds and Commercial Registry Authority, a very important organization in the state apparatus. That is the organization in which all titles are vested and passed. It's the repository of all titles by transport, the company's registry, the registry of business names, deed polls, powers of attorney, and all those important documents. That's the institution at which they are filed and kept. And this building that we visited yesterday, the construction site, is intended to create an office that will house this facility in Essequibo, Region Number 2. Currently, this institution carries on its operations in a very cramped bottom flat of the High Court building at Soddy, and hopefully we will move out of that cramped situation very shortly, and the organization will move into its new abode in due course. All of this is part of the government's transformational agenda of the country. It's a 4-story building, some over 16,000 square foot. It is equipped with elevators. It's going to be fully air conditioned, and there are facilities also to store documents. Storage vaults are going to be built, parking facilities are going to be built as well. There's another building that we inspected yesterday also, and it is a building that will house offices and living quarters for officers of the Director of Public Prosecutions Office on the Essequibo Coast. Right now, Director of Public Prosecutions prosecutors are renting private premises, and they have really no official place to conduct their business. The building that we are constructing at Underneming on the Essequibo Coast will house living quarters for lawyers prosecuting for the state, as well as will house office facilities for those lawyers where they can prepare their cases to present before the judges or juries on the Essequibo Coast. So today also we met with real estate agents, and we continue our public consultations with those stakeholders in relation to the Real Estate Agents Bill of 2023. That's a bill that we will take to the National Assembly shortly. Today, we had our second engagement with the real estate fraternity. They brought a number of recommendations and suggested amendments, which we are currently discussing. The discussions will continue as we continue to work with this important sector to build a transparent and accountable legal framework that will regulate this important sector. This is a multi-billion-dollar sector. A lot of money passes through here, and Guyana's AML, CFT, and fiscal structure has been flagged for non-regulation of this important sector. And this bill is intended to bring the necessary regulatory framework in place to ensure that real estate agents operate in a clearly defined statutory framework, and that they comply with their ethical duties, they comply with their legal duties, and they comply with other important legal responsibilities such as AML, CFT requirements and their tax obligations, etc. It's a very comprehensive bill that will deal with qualifications, registration of real estate agents, disciplining of real estate agents, their ethical rules and principles by which they will be bound, and it will deal with brokers and how brokers are qualified to be licensed as brokers, and the duties and responsibilities of the both real estate agents and brokers, and will provide for additional qualifications and training for these persons engaged in this important sector. So these public consultations will continue, and hopefully within the next 2 months we should be able to complete this important piece of legislation to take to the National Assembly. My operator is signaling to me that we are fastly approaching program time, and I continue to invite you to send me any comments that you may wish, or any issues that you wish me to address, while I continue to deal with other matters that are before us here. We continue to receive complaints in relation to the local content framework and the local content legislation. and government has commenced a review of the local content framework. We continue to get reports that Guyanese are not being afforded a fair opportunity to participate in the oil and gas sector and in related sectors, and that they are being denied fair opportunities to participate. We have said as a government that one of our first priorities is to ensure that Guyanese interests are advanced and are accorded the highest of priority. We did say when that bill was being promulgated that it is the first legislation of its type in the Caribbean, and that we will have to go back to the drawing boards very quickly to adjust it as we become acclimatized to this new and emerging sector. And with every day passing, we are gaining more and more experience in the sector, and our attention is being drawn to issues that require us to address in ensuring that the policy and purpose of the Act is being achieved, which is to ensure that Guyanese interests are protected foremost in this new oil and gas sector. So I want to assure our viewers that that is an undertaking that is ongoing, and the review will involve consultations which we will embark upon shortly. Ladies and gentlemen, this is where I have to say goodbye. We have approached program time, and I want to thank you very much for spending the past hour or so with me. I think we have discussed a lot of important issues, and I want to thank you very much for being with me, and I want to wish you a good evening and invite you to join me next week as we continue this discourse. Please stay safe, stay healthy until we meet again next Tuesday to continue our discussions of issues in the news. Thank you very much and good evening.